May proceed.
Good morning. May it please the court, Bruce Edwards, Assistant Attorney General on behalf of the people. At the table with me is Josh Van Lan, who will be arguing on behalf of Amicus Prosecuting Attorneys Association of Michigan, and Aaron Winston, Michigan Solicitor General. It is well known that Michigan's conspiracy statute makes it a crime for two people to agree to commit a crime. What is less well known is that this statute also makes it a crime for two people to agree to commit a legal act in an illegal manner. As this court's criminal jury instruction 10.2 use note states, this provision of the statute has not been commonly utilized in Michigan. And that's why there's almost no case law that has construed it, and that's why we need some guidance from this court. Now, with reference to the common law provision, I'm going to read just two sentences. This is a book written in 1920 summarizing the common law of England. Where the act contemplated by the parties is in itself lawful, a conspiracy to carry it into effect may still be criminal if the parties agree to attain their end by unlawful means. Such unlawful means must consist of violence, duress, threat, stratagem, fraud, or some other unfair trickery. And that's what we have that occurred in this case. Petitions were submitted to the Secretary of State in order to get then Congressman Thaddeus McCotter on the August 2012 primary, and there were some discrepancies or some flaws noted in the petitions. There was a full investigation. Defendant Seewald and his co-defendant Yao Chang both appeared and answered questions under oath as part of the investigation, and then they were later charged with a crime by the Attorney General's office. And and they had a preliminary examination. After the preliminary examination, their testimony that had been given under oath was admitted as exhibits. So this is a very unusual preliminary examination because defendants 99.9% of the time never testify at a preliminary exam. But in this case, their testimony was admitted, so it was part of the preliminary exam. And it's even more unusual because they confessed to their crimes during their interviews under oath. So, if you take a look at the crime, commit a legal act in an illegal manner, there are three elements. Obviously, an agreement between two or more people. There's no dispute there was an agreement between Seewald and Yao Chang to commit a legal act, and then in an illegal manner. There's no disagreement that an illegal manner was agreed to. They did sign petitions. They did not circulate. So the only element that's in dispute is the second element, to commit a legal act. Now, Seewald has argued the signatures were not valid, and thus he did not ever agree to commit a legal act. However, I would refer the court to Appendix 112A, and that's when counsel for Seewald was speaking to the judge who was going to sentence him on his misdemeanors. And he specifically says, my client signed 9 valid petitions. So when he's seeking mercy from the court to get a short sentence or minimal sentence, he says, oh yeah, they were valid petitions. But now when he's trying to avoid having to answer for the 5-year conspiracy felony, he says, oh, they weren't valid at all. So he shouldn't be allowed to contradict himself like that. Further, both defendants testified under oath that these were valid voter signatures, people that lived within the district and eligible to sign the petitions. And finally, the word valid was used in the charge partially to distinguish the petitions that Seewald signed from some other petitions that were submitted where the signatures were invalid. That part of the case is over. Yao Chang pleaded guilty to 10 felony fraud, election fraud counts involving the bogus signature petitions. But the charge here is relating to the valid voter petitions. Now, it's true that when Seewald and Yao Chang signed as circulators, the statute said at that point these valid signatures should not be counted by the Secretary of State. But when they entered into their agreement, they were still valid signatures at that time. And a conspiracy is completed the moment you reach your agreement. It isn't subject to subsequent acts. In fact, they could have even complied and engaged in this legal act of having these signatures counted at the time they entered into their agreement if they had merely gotten on the phone and tried to track down who the actual circulators were, asked them to come into the office and sign. But instead, they took an illegal mannered shortcut in an effort to have the Secretary of State count these signatures toward the required 1,000 signatures that were needed to have the congressman's name appear on the ballot. Now, Seewald argues that the people's construction of the statute will basically eliminate a conspiracy to commit a misdemeanor because the prosecutor will always be able to manufacture some greater subsequent goal they were trying to accomplish. But that's not really true. In fact, the exact opposite is true. Under the Court of Appeals interpretation, they basically said because there was an agreement to use an illegal manner, it therefore tainted the legal act.
But counsel, and I appreciate you going into this. First off, good morning and welcome to the court today. But I think that is the thing that I'd like you to help me with. Illegal act in an illegal manner, and the issue here of bumping it from a misdemeanor to a felony. And I think this is a very critical issue. So what I'd like you to kind of explain to me is, this is the thing that I think, as you were discussing that, this is the thing that I have concern with, and I'd like you to kind of alleviate that for me. Give me an example under the model that you're using and under the charging scheme that you're using. Isn't it possible that just about any situation you're going to have a legal act in an illegal manner? I mean, doesn't this create a very far-reaching net that would ultimately allow for a prosecutor to take a misdemeanor conspiracy and turn it into a felony? And if you could expound on that, that would be very helpful.
Sure. Well, the defendants could have been charged with conspiracy to commit a misdemeanor and conspiracy to commit a felony, a lawful act in an illegal manner, but because they had already been charged with many other misdemeanors, they didn't need to charge the conspiracy to commit the misdemeanor. The conspiracy to commit the misdemeanor would be, we're going to sign these petitions. That's the conspiracy. The conspiracy to commit a legal act in an illegal manner is, we're going to get the Secretary of State to count these valid voter signatures. And that's a different thing.
Well, I'm having difficulty. It's a framing issue. And usually criminal enterprises, they may have a lawful point at some point in that enterprise. I'm trying to figure out what these two conspired about. They conspired certainly about trying to get invalid petitions to look like valid petitions. My question is, what was the legal act? As soon as I agree to falsify and thereby make unfileable these petitions, how is it the filing of them is a legal act?
Well, for example, if you submitted petitions to the Secretary of State with no circulator signature, that would be a legal act. The Secretary of State wouldn't count them, but that would be a legal act.
Had they tracked down, but I have now falsified,
yes,
which is a legal act.
Right, that's right. But
and I know that if I do that, they are not collectible. So what I'm attempting to do is commit a fraud on the Secretary of State by submitting them.
Exactly, just like the language I read from the 1920s, where it said the unlawful means must consist of, and then example, fraud or some other unfair trickery, even though submitting signatures to the Secretary of State to be counted towards putting somebody on a ballot, that's clearly a lawful act. Political operatives do it every election cycle, over and over. So and the petitions were valid. The signatures were valid. They were actual voters. These were not the cut and paste signatures that Yao Che was separately convicted of.
There were some cut and paste.
Not in the 9 that Seewald signed.
Okay. Well, can I follow through on the questions from both of my colleagues, Justice Bernstein and the Chief Justice? I mean, you spoke at the beginning about 3 elements here. I mean, is there not a 4th element that says something about the nature of the connection or the nexus between the legal act and the illegal manner? And if there is that 4th element, how do we define it so it doesn't become just so attenuated that almost anything can satisfy the connection between the 2 elements that you've identified?
Well, as I argued in my brief, signing of these petitions at the bottom, that had no value in and of itself. Whereas most of the time something will have, if something has value in and of itself, then this charge probably wouldn't be warranted. But it was only an illegal step toward the greater lawful goal of wanting valid signatures to be counted so the congressman's name could be placed on the ballot by the Secretary of State.
So, did that answer your question?
No, that's fine, thank you.
So, here's what's troubling me about this case. So, let's say, which we would never do, but Justice McCormick and I decide that we would really like to buy some marijuana, which we would not do.
That's a That could so totally.
That would be an
happen.
illegal act. But
But we agree about it.
But we agree. We're going to go buy some non-medical marijuana, and we don't have any money, and so we decide we're going to steal some money from the Chief Justice.
That could
He
totally.
has
Five-
plenty.
$500. I assume that's a misdemeanor. And then, but we've agreed, so we've made 2 agreements to buy pot with stolen money. 2 misdemeanors. Now I'm liable for, at most, 2 misdemeanors,
And
right?
a misdemeanor conspiracy.
Right. But if the 2 of us said, you know what, there are all these people who are hungry at Thanksgiving, and gosh, I'd really like to provide Thanksgiving meals for hungry people, but we don't have any money, so we're going to steal Bob's money and give it to the homeless, that's a felony?
Yes, it would be, Your Honor, and that's because, well, yes.
Isn't that, like, what human being would expect that that's how our criminal justice system works?
Well, but first off, several of the examples you've given are all illegal acts.
Sure, the first is illegal. We're gonna commit the illegal act,
Yep.
buying marijuana through illegal means, stealing it from the Chief Justice. The second one is a legal act. We're gonna donate to charity, legal, through illegal means, stealing it from the Chief Justice. The charity is a felony. The buying drugs with our ill-gotten gain is a misdemeanor.
Why do we want to punish Robin Hood more than drug users?
Well, part of the reason is because conspiracy law is concerned about joint criminal activity.
Yep.
And so when
Yeah.
people join together, that's, the law
But
takes that
two
more
criminal
seriously.
misdemeanors get you less time than one criminal act and an act of charity.
Right, I'm conceding they're both conspiracies. We've conspired to do both things, steal the money and then use it somehow.
Well, I mean, that's almost an argument against the legislature having enacted the statute at a certain point. I mean, the prosecutors obviously use discretion in deciding when to bring charges, and they know they're gonna have to persuade a jury, and they're gonna have to, have an appellate review, and even if they are bringing charges, they might get unelected because they're
But my-
abusing
my-
the system.
My question, though, is what is the legal act? Is this something that the prosecutor can create as a theoretical construct?
Right.
The people who, let's just say, they conspire, we know doggone well that we can't legally file these falsified petitions. So they have no agreement to do a legal act. From point one, they know what they're doing is illegal. But do you nevertheless get to characterize their filing as a legal act, even though they thought it was illegal to do that?
Well, I have to challenge the proposition that they know it's a illegal act to turn in the petitions. When you turn in valid signatures, that is not an illegal act.
Yeah,
What
but
crime is that?
that's not what, their conspiracy was to create a filing to qualify somebody when they knew because they'd falsified certain of the petitions, that they did not qualify.
Those particular signatures should not have been counted, according to the statute, if the Secretary of State discovered that a non-circulator had
Correct.
attested that they had
Correct.
circulated.
I'm positing that they knew that in falsifying some portion of these signatures, they were doing something that was not permitted by law.
Well, they knew the illegal
And
manner was
submitting
not
them.
allowed, and that was written right on the petition, the illegal manner is not allowed.
Can we step back again for a second? I want to get back out of the weeds of this particular case because I think it's especially tricky.
Yeah.
Because I think we were making progress in response to Justice Larson's
Stealing my money.
hypotheticals. Because I think what you said, which is right, is, the legislature wrote the statute and the prosecutor has discretion. Yeah, the prosecutor could have charged a misdemeanor conspiracy here, but the prosecutor also could have charged a felony conspiracy, and prosecutors get that discretion. That's the way the system works, and I think you're right about that. So I think we made a little bit of progress from 10,000 feet. How to apply it to this particular case, I think, gets a little bit trickier. But still, I think what the Chief Justice is getting at, and again, I want to stay away from the facts here just to see if we can push this any further. It does feel like the discretion is especially discretion-y in this statute in such a way that concerns us. So just changing the hypothetical slightly, Justice Larson and I want to go to the movies tonight. We really do. This has been a long call. We're tired. We want to go to the movies. But we're poor. She already told you. We have no money. But I know how to sneak into the back door of the movie theater in Ann Arbor, so we decide to sneak into the movies. You could say we just conspired to steal the $7.50 a disc of the movies. I don't even know how much it costs anymore, but whatever. And that would be a
can't afford
misdemeanor
it. We
conspiracy.
can't
Or
know.
you could say, we conspired to watch a movie by the illegal means of sneaking in, right? You could say that. Now, maybe your answer is, yep, I could charge you with a felony. I'm probably going to lose because the jury's going to say, Mr. Prosecutor, that's dumb, right? And that's just the discretion prosecutors get. So that might be the big answer to, yeah, you guys are all concerned with the discretion, but sorry, go talk to the legislature about a statute that gives us a lot of discretion. Is that fair? Does that characterize your position on the?
I think that's fair. The one extra point I would add is that, you know, there was a hypothetical in the Seewald's brief where it says, okay, two guys conspire to steal $2 so they can buy a Coke because they're thirsty. But stealing money has independent value and is a crime in and of itself. Submitting petitions with valid signatures is a lawful act. Further, signing as the circulator has no value in and of itself. It might be a crime, but nobody does it and then just throws it in the wastebasket. It's only in furtherance of the greater goal, which here was admitted to under oath. They were specifically asked, why did you do this? And they said, because we wanted these names counted in the count to make sure we got up to 2,000 signatures.
It can't be that the subjective value of the intervening illegal act is what this turns on. I think you're on better ground to say, yeah, we have some discretion and that's the way it goes.
Yeah, because isn't that our movie, that doesn't change the movie
It doesn't,
hypothetical,
yeah.
right? Because nobody sneaks into the movie theater to, what, buy $10 popcorn? No, nobody does that. You sneak into,
Because you can't afford that anyway.
all right, to
We
watch
can't.
the movie.
I'm trying to figure, this is a helpful exchange, because is it merely that the prosecutor gets to decide on what the legal act is, and I suppose if it isn't negated by evidence, that can be coupled with an illegal act to create the felony?
But I mean, you're
Conspiracy.
almost painting the hypothetical prosecutors might run wild. And
Well, they might.
obviously, I would like to come back to this case and say, well, at least when the defendants, you have under oath admissions from them as to why they were doing it, and that was a lawful act ultimately, and then, yes, they also admit to the illegal manner, the plain text of the statute is satisfied, and they should have to
And
answer
so
for
I'm
their
ready to bring
behavior.
prosecutorial discretion.
Yeah.
That's your answer.
And I'm ready to bring it back to the facts of this case now. I just wanted to take a step back for a second. So, but in the facts of this case, I still think it's a little complicated because I don't know, I think the Chief Justice is suggesting that what they agreed to from the beginning was to
illegal.
fraudulently file petitions. They never agreed to file they agreed to, we gotta get them on the ballot, we can't possibly comply with all the.
And that's the
let's-
illegal manner.
This isn't the
No,
stealing
but maybe
money
it's
for
what-
the charity.
Maybe there was no legally act agreed to if they only agreed to file false petitions.
Well, there was testimony that 4 years earlier, they had done the same thing.
That
and
was
the
shocking to me. I
Secretary-
didn't know all that,
And the Secretary of
yeah.
State never discovered it.
Yeah, I
So
understand
they
that.
believed they had a good chance of not being discovered again,
But
and
that
these
doesn't
would
make-
have
But that
been
doesn't
found.
make it
That makes
legal.
it more illegal what they were agreeing
I
to.
They
don't think
knew
so.
that
It
this
shows
was
that they
possible.
It shows that they wanted to get him on the ballot. That's what they
No,
wanted.
no, but
And using valid
But that
signatures
might
to
mean
get
that-
somebody on a ballot's not an
So
illegal act.
if hypothetically it could be legal, that gives you the authority to charge it. That's
That's
a
the
principle
issue.
that I've thought might work for you. Is
So,
that-
so that it's if the prosecutor can posit a theoretically legal activity, despite what
What actually
the
happened.
conspirators were actually thinking, that's sufficient to satisfy, at least so that you go to a jury.
Yeah, because this was just a preliminary examination bind over, obviously. You know, the burden on the prosecutor is extremely low in that situation.
Sure.
that's-
Could we talk about, I don't know whether to call it impossibility or mistake, but maybe what they agreed to here could never, they thought it was legal, but it is impossible to conspire to do the legal act this way. Is that, so let's go back to the movies, because I'm having a hard time with the petition. Justice McCormick and I agree we're going to sneak into the movie theater to watch a movie that has been lawfully distributed, and therefore it's lawful. But it turns out that, I don't know, it was pirated from China, and therefore our very viewing of it is illegal. Please leave the First Amendment out of this. Okay, so we thought we were conspiring to do a legal act, watch a movie, but it turns out that our watching of the movie itself was illegal from the beginning. Is that this case? Is that where you think we are? Maybe the chief
Very
thinks we are?
possibly.
Is that
So do you get
this
to
case?
posit, well, the act of going to see a movie is theoretically legal, but not in this case?
As long as it can be
Well,
hypothetically
I
legal.
think what you get is two conspiracies. The conspiracy to commit the misdemeanor, the conspiracy to commit the lawful act in an illegal manner. And
Well,
the
but
fact
wait a
that an
minute.
illegal manner exists cannot taint the legal act.
No, wait,
Well,
wait,
but you
that's-
couldn't charge both of those. That'd be double jeopardy, right? You can't
Well, it
charge
would not
both
be double
the.
No.
jeopardy at all.
I mean,
No,
Those
but
are
I
separate
thought
crimes.
that's what your next thing was, that you were, I thought you were saying I would charge that one twice.
No, I would charge the conspiracy to commit a misdemeanor.
I
And then a
misheard you.
conspiracy to commit the felony.
I misheard you.
It's two separate charges, separate elements.
But again, if it is in fact the case that the viewing was illegal, even though I thought it was legal, you can posit that it was theoretically legal to watch it and charge me with the illegal manner.
Especially if you had evidence that the people sneaking in thought it was legal, because, conspiracy criminalizes the
Well, no, no,
intent that people have.
let's change it then. They knew that this is a pirated thing, but they wanted to sneak in and watch it anyway. But you then, as I understand your argument, can posit that watching a movie is a legal act, even though they clearly did not conspire
Yeah, you want to
to
narrow
do
it down
that.
to watching this movie as opposed to watching a movie.
No, I'm talking about this case.
Right.
My two beloved colleagues are sneaking in an Ann Arbor film that they know to be pirated and illegal to watch. Can you charge them under this statute with doing an illegal act, breaking into the theater, which I'm sure they've done many times, to watch an illegal movie? Can you charge them under this statute?
I'm not certain, but if we had testimony from them that they didn't know, then
No,
clearly
no,
I
no,
could,
no,
but if they did know,
they
maybe I would
knew.
not have a
No,
good
that's
faith
my
basis.
hypo.
Yeah, maybe
My
I would
hypo-
not have a good faith basis to assert that it was a legal act, because
That
there's
was
no
what they
question
conspired to break in to watch an illegal
Right,
movie.
right. Then probably not.
Counsel, isn't the arguable virtue of this case that we have a single, there's no end to the kinds of hypotheticals that can be conjured up here, but I'm just thinking that in this case, we have a single statute. That single statute defines what's legal, and it also defines, not only by inference, but explicitly, what's illegal. That seems to me at least potentially to limit the discretionary character of the prosecutor's decisions in this case. Everything is cabined by the four corners of this statute. The illegal manner in which something is done, the legal end, and do we need to get into the world in which there are common law considerations and distinctive statutes that may or may not be in pari materia and may have some impact? Here we have the virtue of a single statute defining potentially everything that's relevant. Doesn't mean that there aren't tricky issues. Doesn't mean that there isn't still some discretion that remains with the prosecutor. But that discretion at least has been very significantly cabined. In other words, what I was inquiring about earlier, the fourth element, the nexus between the illegality and the legality is supplied by the statute itself. Does that make sense to you, what I'm
It
saying?
does make sense, and so, this is a unique case, once again, because nobody's speculating as to what they were trying to accomplish. They said what they were trying to accomplish under oath.
But there may be question as to whether, like my beloved colleagues, they were conspiring to do an illegal act to see something illegal versus breaking in the movie to watch what they thought was they were lawfully entitled to see. That's the framing question. And I'm not sure what I understand these two conspired to do, because it's kind of swirly.
It is, but because of the illegal manner, because they admit to that, they should not be able to avoid, and that does not taint the legal act they were actually trying to accomplish.
I think you would say, hey, maybe we'll lose, but
It's
we're
a
gonna
jury
we're
question.
gonna let the jury decide. You defendants go to trial, take the stand, say we only intended to commit crimes, 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 crimes. And if you win on that theory, go for it. That's
Yeah,
what you would
they can
say, right?
say the prosecutor hasn't proved the element of a legal act, and
Right.
then we can give the counter argument, and then it's up
We
to the
did
jury.
nothing legal,
But the-
nothing at all.
That's what I hear in
Except for
conference
the
all the
illegal
time.
manner.
You have 5 minutes remaining. Do you wish to reserve?
Yeah.
Oh, who's going?
Oh, I'm sorry.
Do you want to, well, you guys,
Oh, I'm sorry. I didn't realize
Rock,
that
paper,
you
scissors.
had split your time. Excuse me. Go ahead.
Good morning, Your Honors. May it please the Court. My name is Joshua Van Len. I'm representing, I'm here on behalf of the Prosecuting Attorneys Association as an amicus. To the extent that an amicus is allowed uninterrupted time, I
You're
certainly
sitting
waive that.
here,
Absolutely.
so use it.
And I would waive any interruption, ask any questions that you may have. But I think the overall gist of this entire case is that there are two things. Number one, with the Court of Appeals ruling, it violates the separation of powers for two reasons. One, their interpretation of this statute essentially is, I would say, the opposite of these hypotheticals that you've been throwing out. In every situation, the Court of Appeals will find an illegal act. So as you're saying that every situation you could find a legal act in this broad scope of things, the way the Court of Appeals is interpreting it is that in every situation you can find an illegal act. And when they do that, they completely nullify the conspiracy to commit a legal act in an illegal manner. And so that interpretation is 100% not allowed by the rules of statutory interpretation. So we certainly know that the Court of Appeals was not entitled to interpret the statute in that manner. Not only does that violate the separation of powers as to the legislative ability to create that statute, but as to the prosecutor's discretion in, of course, charging either, in a case like this where they arguably could have committed both types of conspiracy, the prosecutor then has the discretion to charge either of them. And based on the scope of the conspiracy, which is a question for the jury can decide whether the scope is a legal act or only an illegal act. The second issue kind of is involved with the first, and that's...
But counsel, good morning. It doesn't worry you that it's just a little overbroad in terms of this situation? I mean, because it's hard to figure out a situation where you don't have a conspiracy that has a legal, that would have, if you can give me an example of a situation where you wouldn't really have a conspiracy of a circumstance where you wouldn't have the opportunity to charge as a felony. That's, I think, the concern that I think you're hearing today is just the overbroadness in terms of the vagueness of this, where you could have a situation where it's hard to find a circumstance or situation where you wouldn't have charging authority to charge people with a felony, no matter how small the circumstance could be.
I don't necessarily disagree, and I think that's where it falls on the discretion of the prosecutor and the checks and balances of the jury being there to decide whether or not the scope of the conspiracy amounts to what the prosecutor's alleging. One of the questions that were posed was whether or not...
And you felt that that's what the legislature's intent was to allow for this, to allow for, let's say, two 18-year-olds who buy a stick of gum to be charged with felony conspiracy, or do you feel that it was intended for something different? I mean, just on a logical perspective, do you really feel this is what the legislature had intended in terms of how it created the statute?
I absolutely believe the legislature intended to allow the prosecutor the discretion to charge based on the agreement itself. The conduct is really unimportant when we're dealing with conspiracy. So if these two conspire to steal a stick of gum and that's their conspiracy, there's no conspiracy to commit a legal act. We have to look at the agreement. In this case, we have to look at the agreement. In any other case, we have to look at the agreement. What did they conspire to commit? And that's how you limit the scope, and that's how you reduce...
But I guess I just want to go back to the hypothetical. I don't want to go too much of your time, but I'm very focused on Justice McCormick's hypothetical about the movies. Two 18-year-olds sneak in to go to a baseball game, and you feel that the legislature felt that the prosecution should have that discretionary authority to charge those two 18-year-olds with felony conspiracy if they snuck into Tiger Stadium.
If their agreement was only to sneak into Tiger Stadium and that's an illegal act, there is no legal act that was agreed
Viewing the
upon.
game.
Excuse me?
Viewing the game's a legal act.
I'm sorry,
Watching the game.
Watching the game is a legal
They
act?
agreed to watch the game.
and if that's what their agreement was, and you can prove that their agreement was to go watch the Tigers game, but the manner was to
Manifestly,
sneak
I don't
into.
think teenagers break in to do anything, if they're going to Tigers, to see the Tigers, that's what they're doing.
And that's exactly what the defense would argue to the jury, is that they didn't agree to commit any legal act, they agreed to illegally break in. And
This concern about overbreath, isn't there some additional specificity required in the pleading by the prosecutor and the information when the allegation is that the conspiracy was to commit a lawful act by unlawful means?
I believe there is. I think the specificity is you have to state the lawful act they intended to commit, as well as the illegal manner that they intended to commit it, which was done in this case as well. I believe it.
Is that more particularized pleading than in ordinary crimes, or is it the same level of specificity in your view?
I think it's more particularized because in a general conspiracy to commit an illegal act, it would just be the crime itself without the manner in which you completed.
You have to
that
plead
crime.
the elements of the crime and the
Right.
information.
The information typically, in a conspiracy though, the conspiracy would say they agreed to commit
I'm just asking an element, is it required that the prosecutors spell out the elements in a conspiracy, all of the elements?
I would say in the information, I don't believe that it's required they spell out all of the elements, although the elements themselves are kind of confusing. I guess they don't need to define certain terms, but they do need to make sure that there's enough notice of what he's being called upon to defend. So I would say probably.
Thank you.
Thank you.
Morning, Your Honors. My name is Keith Madden from the law firm Fosso and Bond LLP. With me is another attorney with the firm, Mr. Michael McNamara. We represent the appellee, defendant Paul Seewald, in this matter. Your Honors, the appellant would obviously like you to view the conspiracy statute from the perspective of a prosecutor. We believe it's equally important that you view the precise wording of this statute from the perspective of a citizen in this state. Under Michigan law, citizens are deemed to have constructive notice of what's prohibited in the criminal law. It's important to ensure that they have a fighting chance to determine what those prohibitions are. As stated in the appellant's brief, this is in the appellant's brief, they cited People versus Tinsky. In that case, the court stated that the somewhat indeterminate common law definition of conspiracy to accomplish an unlawful purpose was replaced by MCLA 750.157A to define the term conspiracy to prohibit, quote, any person, unquote, from conspiring to commit a legal act in an illegal manner. The statutory definition of conspiracy replaced the common law definition. This is a confusion that is, we did not inherit all of the common law scriptures. The statute does not include the concept of any goal or objective of the conspiracy. That was a common law. And that's what's claimed throughout appellant's brief, is that it's the goal or the objective of the conspiracy that's important. Instead, the statute precludes a person from, quote, conspiring to commit a legal act in an illegal manner, unquote. That's the definition. As addressed in the appellee's brief, at no time did the appellant have the authority or the ability to himself place the congressman's name on the ballot or to submit ballot signatures as stated in the charging document. Now again, viewing the law from the point of view of a citizen, not a prosecutor, there's also a statute which specifically says that it's a misdemeanor to falsely sign a petition. And that statute number is MCL 168.544C, parents 8, but it was later changed to subparagraph 11. As both the Circuit Court and the Court of Appeals have held, the appellant in this case is actually trying to stretch the clear, concise language of the conspiracy statute and the election law to add further penalties where they were never intended by the legislature. The majority of the Court of Appeals stated, it's thus impossible for defendants to have conspired to commit and this is a quote, a legal act in an illegal manner under the statute because defendants did the exact opposite. They conspired to commit an illegal act in an illegal manner. The prosecution attempts to circumvent this rather obvious fact through citation of defendants' admission that their ultimate goal was to place McCotter's name on a primary ballot, which the prosecution says in and of itself is a legal act. This expands the scope of the conspiracy beyond all reason. Now, in addition to this problem, there are three other fatally flawed problems with the appellant's argument. The charging document in this particular case did not state that the alleged legal act was to get the congressman on the ballot. It said the legal act was submitting nominating petitions with valid signatures to the Michigan Secretary of State. Both the Circuit Court and the Court of Appeals properly held that it is impossible for the appellant to conspire to submit valid signatures to the Secretary of State because the signatures were invalid and illegal when they weren't signed by the actual circulator. The second fatal flaw in the appellant's logic is the appellant's claim that the legal act in the alleged conspiracy was getting the congressman's name on the ballot. The problem here, it is impossible for the appellant or defendant Yao Cheng to commit the act of putting congressman's name on the ballot. That's done by state officials. The statute does not say that a person shall conspire to have some third party commit a legal act, as claimed by the appellant. It precludes the conspirators from conspiring to themselves commit a legal act in an unlawful manner. Now, there's a third fatal flaw, and this was brought up in some of the questioning that I heard earlier. The third fatal flaw in the appellant's argument, there's no boundary beyond which the appellant is precluded from stretching into the future to point to something that is legal. Because there's no boundary in the appellant's search to include some legal act, it's possible for the appellant to charge the felony of conspiring to commit a legal act in an unlawful manner in virtually every case which involves the misdemeanor of conspiring to commit an unlawful act.
You agree, though, that the construct that the prosecutor is suggesting here is that the prosecutor gets to argue first in charging and then presuming they get to...
No, I don't. And the prosecutor is making... I'm sorry, could I explain? The prosecutor...
I hadn't finished my question.
Oh, I am sorry.
I believe the prosecutor's view is that they can come up with a theoretical legal act and tie it then to the... Now, so I'm asking in that context, what do you contend that your client conspired to do here?
What did my client conspire to do? They conspired to sign the petitions.
Okay. And illegally sign them, right? It's a misdemeanor to...
In violation of statute, sure.
Right. Now, the goal was to get Cotter's name on the ballot as they had done before. These two conspired before in the prior election to submit falsified petitions, which actually got through.
Well, that was the question that was asked at their interview, and it said, and your goal was to put the congressman on the ballot, and they said that's correct.
Well, what else would it have been?
Their goal may have been to retain their job. It could have been anything down the road.
Well, that's
this
legal.
is my point. The prosecution has the ability to go way down the road and say, well, here's a legal act.
But in this particular instance, it's not so fanciful for the prosecutor to say they wanted to do something which was perfectly logical, which was to get Cotter's name on the ballot. I agree with you. They couldn't effectuate that because they're not the Secretary of State.
Correct.
But they can do the predicate, which is to submit the signatures and hope that the fraud they're committing on the Secretary of State works again.
And if Mr. McCotter had gotten on the ballot, as noted by the Court of Appeals, that in itself would have been unlawful.
But at this point, the submission of them to the Secretary of State itself was not an illegal act, was it?
The submission of the petitions to the Secretary of State was an illegal act.
Wasn't.
It was. It was
Tell me why.
fraud on the Secretary of State, is misrepresenting the
Fraud, yeah, it's a fraud.
That's illegal.
Civil fraud, but it is, why is it an illegal act? What statute?
A legal act?
Yeah,
No, I'm sorry, I misheard you.
the submission of these falsified petitions clearly were fraudulent,
Correct.
but why were they illegal?
They were
Civil fraud, clearly, but what makes them, the submission of them
It would be
illegal?
criminal fraud as well to misrepresent the validity of those petitions.
A criminal fraud?
With a
There's
petition.
probably a criminal fraud. You can't like just submit, come on, that's gotta be a crime.
All right, there you got it.
Sort out later why so, but,
Can
but
I
I,
s-
but I wanna go back to what it sounded to me like you said you had this one overarching complaint, the statute's too broad. But in your brief, you said it was clear and unambiguous.
It is
So
clear
which
and
did you mean? Do you
unambiguous.
mean it's?
Number one, they had to do the commission. We pointed that out, not the Secretary of State. So it doesn't apply here, okay? But there's another problem. The prosecution has the preconceived notion that if the unlawful means somehow taints the legality of what the proposed legal act is, then we should still be able to make a hypothetical that that would have been a legal act.
But why aren't they right that that's for a jury to sort out? Like maybe they're let me just finish. Maybe they're aggressively charging here. Maybe this is an aggressive charge where, they're going to say to the jury, yep, they were conspiring to get him on the ballot, or they were conspiring to file petitions, which hypothetically is a legal act. And here was the illegal manner in which they did it. And why can't your client get up and tell the jury, I never, ever, ever agree to do anything legal at all. I don't agree to do legal things. I didn't hear. Don't convict me.
It's the hardest thing in the world for a lawyer to say.
Well, I know it's not going to be a fun trial. I'm not, but that's, you get paid to do not fun things all the time, right? You're here.
Actually, I believe that this statute wouldn't even be applicable in this situation, and it is applicable. The place that it is applicable, and this is why it doesn't come up all that, is the Duncan case that we cited. And if you look at the Duncan case, okay, that was the two cops that gave back the possession of some property from the property room to a lady, but in the process, they solicited a bribe.
And if you were representing them, you would come to us and say, all they did was agree to commit a bribe,
Commit a
right?
bribe,
No,
right.
That's what you would say. Yeah.
I would say that they did commit the bribe was connected to the legal act that they did, and they actually did a legal act.
And the falsifying petitions
the unlawful
wasn't-
manner didn't taint the legal act. They still gave them the property back, and they did it themselves, and it falls right into this statute. There is nothing in this statute that leads me to believe that you can argue that if the unlawful manner taints the legality of the alleged hypothetical legal act, that somehow it's still a legal act. It doesn't say that in the statute, and we don't look at the common law.
Give me the limiting principle that you think we should be applying to this statute, so we understand when it's permissible to use it.
I would say that the Duncan case is a prime example of when it would be applicable.
That may be an example, but I'm asking you for the legal principle. If you want this court to rule in favor of your client, there must be a legal principle by which that occurs. What is that? Other than saying the statute is incomprehensible. What is the legal principle that we tell the prosecutors, you can use this statute when?
Well, there has to be a boundary. You can't go on forever looking for a legal act.
That's not a legal principle.
What's the
Okay.
boundary? That's what we're looking for.
I can't tell you what a good boundary is. I know that the
You just,
But it's not here. Yeah.
It's not here.
Why
The
isn't
appellant suggests it's where there's a value to whatever.
what do you think your function is here today?
My function here is to assist the court.
Well, I'm asking you to assist us by giving us, you say it's got to be, it can't be boundless. What's the boundary?
I am telling you that the boundary is the limitation set forth in the Duncan case.
What is
There
that?
has to be an actual legal act that the conspiracy has an ability to perform. Okay?
So not a hypothetical legal act.
Not a hypothetical one. There has to be an actual one.
Okay.
And it has to be something that they can perform.
Have performed.
And if the alleged legal act becomes illegal because of the manner in which they do it, that no longer applies as a legal
But
act.
that's so post hoc. I mean, if the question about conspiracy is what we agreed to. So we're supposed to figure out the elements to what we agree to up front, post hoc, after we figure out if they actually can be legal? That
Well,
feels
that would
confusing.
be under the common law, that would be absolutely accurate. I mean, but the statute says you conspire to commit a legal act. And it's odd to call it committing a legal act, because nobody really says that in the real world. but-
Why doesn't the statute here provide precisely the boundaries? The statute defines specifically what constitutes a violation of the law, and the statutes that are in pari materia here
Correct.
also define specifically what is the purpose of this whole enterprise, which is to get these petitions aggregated together and filed with the Secretary of State. There's a purpose to
Right.
that process. The process is defined, and the breach of the process is defined. Why isn't that the limiting principle here?
That principle will work, but in applying the principle to the instant case, this would be a conspiracy to commit an illegal act, once again, because the submission of the petitions and the...
But you may arguably be overlooking the fact that the statutes also define what it is that this process, when complied with in a legal manner, is designed to achieve or to effect.
Then you're getting so far into the hypothetical that you're allowing the prosecutor to
No,
actually
it's
write the law.
defined by within the four corners of the statute.
There's no limitation on that. I use my example that everybody's been talking about, the two kids that want to buy a Coke and out of a machine. They're thirsty. And they say, okay, there's some change in that car over there. And they conspire to steal the change. It's perfectly legal to buy a Coke. It's perfectly legal to quench your thirst. Can they be charged with a felony for that small misdemeanor?
Well, what if the answer is yes?
Yeah, what if the
What if
answer
the
is
answer
yes?
is
So
yes? The-
across the criminal code, there are all kinds of ways that prosecutors can charge the exact same act as a felony or as a misdemeanor. And our system says, well, if you can charge it as a felony or a misdemeanor, the prosecution gets to choose that.
I agree.
Why
but-
isn't that this?
Well, some common sense has to come into it.
Well, and
Like
we
I
rely on the
asked at
prosecution to
beginning,
have common sense, right? And they run for
If
election.
you look at
and-
it from the perspective of the citizens, okay? There's a statute that says that it's unlawful to sign as a circulator if you're not the circulator. If that citizen were to look at the statutes, he would say, okay, that's a misdemeanor.
So your claim is lack of notice, or your
There's
claim is
no
the
notice.
statute is
It's
vague?
up to the creativity of a prosecutor to discern whether or not he wants to, to enhance the penalty all the way to a felony, and no specific legislature authorization or any element of legislative intent. In fact, the legislative intent in this case is that the legislature didn't think signing as a circulator was that important and made it a misdemeanor. If they had really thought and then submitting them was that important and that violative of the law, they would have made it a felony in the election law. They didn't. I don't think they anticipated that a creative prosecutor was going to stretch the conspiracy statute.
But then what is the statute for? So we need to not, unless we're going to say the statute itself is void for vagueness or something, except your brief says it's crystal clear, so that's
I
kind of a
think it can
problem.
be.
But if we're going to give effect to the statute that the legislature has written, how do we do that?
I think it couldn't be strictly construed. As I said, one of the elements is that it has to be, of the conspiracy, has to be something that can be performed by one of the conspirators, not some third party. I think it can, if you look at the Duncan case, it was strictly construed and it's strictly applicable. They did a legal act, which was returning the goods. They did it in an unlawful manner, which was taking a bribe. There was no talk, well, there isn't any case law in this, but this idea has been engineered and created by the prosecutor
But
that
did
if the unlawful manner somehow taints what they think is legal, that still applies. The statute does not say that. It says to commit a legal act, not something that might, a tainted legal act. It says a legal act. To commit a legal act in an illegal manner.
So your position is
It's
the
strictly
movie
construed.
theater, when Justice McCormick and I agree in advance, we will sneak into the movie theater to watch a legal movie, but sneaking in is an illegal means, that the prosecutor could charge us with.
That's
But
correct.
what they can't do is charge your client because the very submission of the signatures made the submitting the petition an illegal act.
Correct. That's absolutely
So I
correct.
understand.
Anything else?
No, no, sir.
I'd like to ask Mr. Edwards a question
Thank you.
about that last point. Would you care to respond?
I'm sorry, you're gonna have to repeat it for me.
Well, where there is a agreement to commit, well, let me just ask him directly. Is it a legal act to knowingly submit falsified petitions to the Secretary of State?
Right, it's our position that's not a crime.
It's not a crime.
It's
Why?
not a crime.
Why isn't it a crime?
Well, what crime is it? It's not false pretenses.
Fraud.
Because that's not a crime. Is there a crime? I've never heard of someone being charged with fraud as a crime.
Okay.
I mean, it's not a crime. And just contrary to opposing counsel's argument, the legal act that we have alleged is not placing the name on the ballot. Of course, only the Secretary of State can do that. The legal act we have alleged is submitting names of actual voters who live in the district to the Secretary of State. And that is a legal act, but it was done in an illegal manner. And therefore, we ask that you would
Thank you.
reverse the Court of Appeals. Thank you very much.
Case is submitted.